Amendment Bill 2016, order for second stage and second stage. Senator Bacik, when is it proposed to take second stage?
Now.
Is that agreed? Agreed. The question is that the bill be now read a second time. Senator Bacik, you have 10 minutes.
I'd like to begin by welcoming Minister Bruton to the House. Thank you very much for being here, Minister, to take the bill and to take the debate on the bill. And I really welcome the opportunity to introduce this important bill to the House. And I'd like to welcome also in the public gallery those with a real interest in this matter, in particular representatives from SIP2, from the NUJ and from Equity, among others. And to thank Minister Éireann, who met with us earlier. And who I know is a strong supporter of the bill. This bill stems from a long-standing Labour Party commitment to ensure protection of the right to collectively bargain for freelance workers, including journalists, actors, but also others who perform their work on a self-employed or contract for services basis. Under competition law, self-employed persons are considered to be separate, independent economic undertakings. And if the Competition Act 2002 were to be applied with full force and effect to trade unions and their members, indeed, as the explanatory memorandum to the bill suggests, trade unions would revert to their old common law status as unlawful combinations, and trade union leaders would be prosecuted as parties to a criminal conspiracy. Now, clearly that's not the case, but the point about this bill is to seek to set aside or to exempt certain groups of workers from an overly rigid application of the Competition Act. Currently, if one self-employed person combines with others to set prices for their services, the risk under current competition law is that they could be accused of an illegal anti-competitive practice. And at its most extreme, freelance journalists in a newsroom would be barred from bargaining collectively with their common employer about their wages. Now, I know the Lascahirlic, the chairperson today, raised with me, and as indeed did others, the issue that in fact minimum rates are being set by some unions in respect of freelance workers and continue to apply. But the reality is that the 2002 Competition Act, as interpreted and applied by the Competition Authority, has had a chilling effect, as union representatives have told me. It has had a chilling effect on those unions who represent freelance workers, and it leaves freelancers vulnerable. Employers can effectively use the 2002 Act and its interpretation by the Competition Authority to avoid the bargaining of minimum pay rates with unions in respect of freelance workers. Now, the background to this bill is that the European Court of Justice has recently held, however, that a worker is not genuinely freelance or independent of their employer if the worker acts under the direction of the employer as regards freedom to choose time, place and content of work, and it forms in reality an integral economic unit within the employer's undertaking. And this category of worker is entitled to bargain collectively. This was the European Court of Justice decision in 2014 in FNV Kunsten Informatie and Media against the Netherlands. And arguably this case has direct impact on Irish competition law and indeed is helpful in providing support for the principle that is being put forward in this bill. The commitment to introduce a bill like this is also contained in the Labour document published last week, Standing Up for Working People. This bill shows the seriousness of our intent to act on the reforms within the document. And I want to describe a little more the historical background to the bill and to speak about its origins before just looking at the provisions in it in a little more detail. The historical issue, as I've said, is described in the explanatory memorandum. So the issue of the application of the Competition Act to freelancers has been an issue of contention for some time and of serious concern to the trade union movement. And I should declare a professional interest as I advised a number of trade unions on this issue some years ago in my capacity as a barrister. In 2004, the then Competition Authority ruled, in applying the Competition Act 2002, that a collective agreement between Irish Equity and the Institute of Advertising Practitioners in Ireland in respect of voiceovers provided by freelancers, that this was a breach of Section 4 of the 2002 Competition Act, on the basis that each actor was a separate business undertaking and it was therefore unlawful for them to collectively fix prices for voiceover services. Now, I'm told this ruling then went on to affect all those engaged in acting in visual commercials, but indeed it's had a chilling effect and could affect many others, as I've said, journalists, but also photographers, writers, musicians, models, bricklayers and other skilled tradespeople in the construction industry and other professionals. And indeed, if one looks at the Dutch case from 2014 that I mentioned, that of course related to musicians, to orchestra members who were ostensibly self-employed musicians, but whom the court found to be potentially to be false self-employed or bogus, in other words, that they were in effect employees. The competition ruling also had an impact on representative bodies such as the IMO, and that's really the sort of the issue with which part of a further section of this bill is concerned. Now, as I said, there is some background to the bill. In 2006, then TD Michael D. Higgins published the Competition Trade Union Membership Bill, which would have permitted collective agreements between individuals who engage for gain under a contract personally to do work or provide services. And this issue was then pursued by unions in national agreement and partnership negotiations, and a previous government in the programme entitled Towards 2016 made a commitment to deal with the matter, both in respect of freelance workers and in respect of representative bodies, by way of amending legislation. I understand that the EU-IMF Memorandum of Understanding then posed an obstacle by providing that that there was a need to ensure that no further exemptions to the competition law framework will be granted unless entirely consistent with the goals of the EU-IMF programme and the needs of the economy. Deputy Emmet Stagg in 2012 then published the forerunner of this bill, in fact the bill on which this is very much based, the Competition Amendment Bill 2012, with the same aim as Michael D. Higgins' earlier bill. And I understand also that the correspondence from the EU-IMF and indeed that the EU-IMF corresponded with ICTU in 2012 as grounds for a reason not to proceed with this sort of amending legislation. However, obviously things have moved on. The issue remains a very live one for very many freelance workers in various different fields, and indeed for the unions who represent them. And it also remains, we've come out of the programme happily, and we are in a phase of economic recovery very happily. And indeed, we've now got the 2014 judgment of the Court of Justice of the EU. And I should say that in that judgment, the Dutch domestic law was very much equivalent to our existing Competition Act. And therefore, I would say that the decision has a very direct relevance to the law in this country. Now, I know that in January of last year, ICTU wrote to what is now the Competition and Consumer Protection Commission, asking them to reconsider their position and to reconsider the 2004 interpretation in light of the ECJ judgment. I understand they didn't agree to reconsider at that point. But I think that the decision does pave the way for a bill of this nature to be brought in. And I just want to turn to the specific provisions of the bill, but to say very briefly that, of course, there is a serious issue about consumer protection. It's very important to say that any exemption from the normal application of competition law must be narrowly drawn to ensure that consumers are not put to any detriment. And it is, of course, a knotty business to distinguish between self-employed contractors on the one hand and employees on the other. But I think we're all conscious that atypical employment, involving people who aren't obviously either self-employed or employees, is a growing phenomenon, and that people often describe themselves or are described as self-employed for a variety of reasons, tax, PRSI or pension purposes. And what the ECJ decision does is it says we must look behind that description to see what is the reality. And I think that's very helpful for a bill of this nature. So briefly, the provisions of this bill, Section 2 of the bill is the core section, and it's the section which would provide the protection I speak of for freelance workers as represented by their trade unions. And in the bill, we use a definition saying that where an individual engages for gain under a contract with an undertaking personally to do any work or provide any services, that then a trade union should be able to negotiate effectively on their behalf in terms of their terms and conditions. So it's a new litmus test for what constitutes an undertaking or an individual to whom the Competition Act applies. It's a core point in Section 2 is to enable trade unions to organise and to negotiate collectively on behalf of those individuals who enter into or work under contracts personally to do or provide any work or services, the emphasis being on the word personally. And we say that this would protect those freelancers who are currently facing this legal uncertainty, but it would also prohibit self-employed individuals from price fixing against consumer interests. So it would retain the core public interest principle of the Competition Act. The exemption from the application of the Competition Act would apply only to contracts with undertakings, not with consumers. So I think that's a key component of the bill. I would say Section 3 of the bill is designed for a different purpose, to allow for collective negotiation and bargaining in relation to terms and conditions of a scheme whereby services are provided to the public by members of a trade or so on. And it really covers issues such as negotiations with the IMO. But to me, the core part of the section in this bill is Section 2. I would urge colleagues to support this. I think it's important because adoption of this bill, and in particular Section 2, would end an unfair and anomalous situation where many vulnerable workers are denied protection of collective bargaining rights on the basis of what is an overly rigid and arguably against the ECJ's interpretation of competition law. And I urge colleagues to support the bill.